Good afternoon, student friends. It gives me a great deal of pleasure for the purpose of delivering another topic of business law, that is your international contracts of sale. Here, I'll be discussing on the historical background of international contracts of sale. What are the applicable law to it? What are the rules attached to it? What is a model contracts and what are the clauses? How one should go for an assessment of sale of goods by transfer of property with certainty and with flexibility? What is CISG influence on individual national system and the regional efforts? And all of us, we have witnessed COVID-19 pandemic, and so COVID-19 pandemic and what are its impact on the performance of international sale of goods contract. So after hearing, a student will be able to explain what is the meaning of international sale of and what is the background of the contracts for the international sale of goods and what is the relevance of the contracts for international sale of goods and what are the applicable law and rules which are made for international sale of goods and what are the different model contracts and attached to it the clauses contracts for international sale of goods. So let me give you a very befitting introduction. We have all gone through liberalization, we have all gone through privatization, we have all gone through the globalization. And in short, we call it as LPG era. And in fact, this LPG has wiped out the boundaries amongst countries and made this world as a global village. So for all purposes, reduces distance, increases connectivity, using the technology. So there were different substantive laws relating to contracts and that too in different legal systems which will conflict in legal scenario. So that is why when we talk about this, it paves the way for better thinking of uniform laws and that is comfortable to both the parties and that too from different countries when they enter into the contract and contract with flexibility and contract without any kind of having bias. So what we are more concerned about, we are more concerned about the transaction. And in particular, it is the transaction of sale and that too happening at the international level. So obviously, they are considered to be the, I would say, backbone of international trade through international contracts. So the contracts, when we go for, they're all regarded as international contracts. When the parties to the contract, they're all coming from two different states. And since we are using international, obviously states means countries. More flexible definition are also possible, such as contracts with significant connection with more than one states. And this is involving a choice between the laws of different countries, between the laws of different states, or you may say it is affecting the interest of international trade. So, as it is described in the Hague Principle, there is one approach to identifying contract as commercial, maybe where you find that each party, because there are parties to the contract and each party is exercising some kind of its trade or profession, because as per Hague Principles, Article 1.1, another approach is also found out in the United Nations Convention on Contracts for the international sale of goods. In short, we call it as CISG, which limits its scope to commercial matters by excluding, in fact, for example, your consumer contracts such as goods which are purchased for personal use, goods which are purchased for family use, goods which are purchased for domestic use. This is as per CISG Article 2A. So there were two different important questions which are vital to be answered when a dispute arises. And this dispute between two parties, and that too in an international commercial contract. They one question, if I put that where the dispute of the parties is to be heard, that means the seat of settlement of the dispute. Another question I put that what are the law, what are the rules, in fact, that govern the contract. That means you are interested to know the choice of law by the parties to the contract. So when we go for answer to the above questions, it is quite obvious they are to be made by the parties to an international contract where they opted an arbitration clause in their contract, because the purpose with an intention to avoid the litigation in the local legal systems. And apart from that also, if we look at the application of the substantive law of the countries to which the parties belonging, so the international commercial arbitration may be particularly popular because unlike your court proceedings, there is single, nearly very, I would say, comprehensive regime for enforcement of foreign arbitral awards. So with this befitting introduction, let me tell you something about the historical background. The difference in laws are by products of different histories, you can say different philosophies, or your world views. So uniformity is often difficult to achieve. So that is why one of the major challenges normally faced by an international contract of sale, that is the diversity of legal systems. So since you will have diversity, obviously the conflict will come. So the conflict of laws exaggerated worldwide because of the global supply chains and the contractual networks which operates across globe. So when we come across 20th century, obviously the 20th century, what it does, it focuses on uniform framework and uniform framework so that we can be able to tackle the situation of the diversified legal system. So before the World War, and that too Second World War, Honest Ravel suggested one thing, the possibility of the uniform sales law to the Institute of Harmonization of Private Law. So way back in 1930, the Unitroid initiated the project, and the project was to prepare some kind of law unifying the substantive rules governing your international sales contracts under the auspices of the League of Nations. So in 1935, the Commission of European Scholars, what they do, under the leadership of your Ravel, they prepared some kind of preliminary report. Though the Second World War was interrupted, the work it was again resumed in 1951. So it was resumed in 1951 in the Hague Conference. So in 1964, two conventions, namely Uniform Law on International Sale of Goods (ULIS) and Uniform Law on the Formation of Contract (ULF), unifying the law of international sale of goods, were adopted in that convention, and that came into force way back in 1972. So these are still not widely, I must say, recognized outside Western European as instruments of your international harmonization. So the establishment of your United Nations Commission for International Trade law in 1968, in fact, paved the way to draft a new unified sales law. And the final draft of the Convention on the International Sale of Goods, in short, we call it as CISG, approved by the General Assembly of United Nations in 1980, and that came to operation on 1st of January 1988. So the CISG is now very much supported by the number, the number of conventions like the United Nations conventions on the limitations period in the international sale of goods, the 1983, the Geneva Convention on agency in the international sale of goods. Similarly, in 2005, Convention on the use of your electronic communication in international contracts. The 1983, I am reminded of the uniform rules on contract clauses for an agreed sum due upon failure of performance. So 94 countries they ratified and they accepted the to the convention as of 2020. So the CISG is the best example of unification of private law, whatever we have done till date. So there are, in fact, no statistics available to provide the success of the CISG in developing international trade. Obviously, the ratification doesn't mean that the unification, which we are more concerned about, the unification of international sales law effectively, and it provides the contractual parties with a useful regulatory framework, with an efficient regulatory framework. So CISG is based on the principle of party autonomy. So the parties are at liberty to adopt, or the parties are at liberty to exclude the applicability of the principles laid down thereon in the CISG. So the ratifying state may ratify in total or with certain restrictions, which in fact creates uncertainty to the fact that the convention, which we are more concerned about, is a unifying law on the international sale of goods, and this creates in the provision of the convention. So in interpretational disputes, the national courts and the arbitral tribunals, they have to take the international character and and the uniformity they have to maintain in its application and observance of good faith in international trade into consideration. So CISG doesn't specify or doesn't state a list where these principles are and consequently have to be deduced uh, from the other provisions of the conventions through a process of analogy. So the judge may venture, no doubt about it, outside the four corners of the CISG and settle the matter in conformity with the applicable law. So it is quite clear that the CISG doesn't unify the law of international sales in an exhaustive manner, but instead operates in a supplementary relationship, operates in a symbolic relationship with the national law and with the trade uses or party autonomy or other, you can say, international instruments of harmonization. Now, coming to the applicability of law and rules, that means applicable law and rules. First, when we talk about the conventions in some international cell contracts, the law applicable to a contract will be provided in a treaty. So we have United Nations Commission on International Trade Law. It has created three treaties, and they have all they have the treaties have been created that provide the applicable rules governing certain contracts. What are they? First is your United Nations Convention on Contracts for the international sale of goods. So the United Nations Convention on the Contracts for the international sale of goods is the most, I would say, widely adopted treaty, providing substantive contract rules. So here, the CISG's scope is very much limited to your commercial contracts for the cross-border sale of goods. Successful implementation, if we look for, of the CISG, very much it requires more countries to adopt it and parties to use it. Obviously, the courts and the arbitral tribunals must also interpret the CISG in a more uniform manner and not through the lens of domestic laws. Number two, treaty that we are more concerned about, that is your the convention on the limitation period in the international sale of goods. The convention which we are more concerned about uh, on the limitation period, that to in a international sale of goods, is a sister treaty, rather I would say, to the CISG. Originally adopted way back in 1974, it was all amended in 1980 in order to, the amendment was brought about in order to operate seamlessly with the CISG. So the limitation convention applies to the same types of international sale contracts as the CISG, and with the, this is with the same scope of application. But one thing I must tell you, but its substantive provisions deal solely with limitations, solely with its prescriptions, providing a sort of statute, statute of limitations for international sales disputes. So the general period of limitation provided in the limitation convention is actually 4 years. And till date, if I look at, there are 30 state parties to the limitation convention, whereas 84 state parties in the CISGs. As is the case that we are more concerned about with the CISG, parties may also opt out of its provisions. So the rule of uniform interpretation for the limitation convention generally the minor, those found in the CISG. So the third treaty is the United Nations Convention on the use of electronic communication conventions in international contracts. As a matter of fact, the United Nations Convention on the use of electronic communications in the international contracts is a much more recent one treaty than the CISG or Limitation Convention adopted in 2005. It currently has 7 state parties, and the purpose of the treaty is to remove any kind of legal obstacles to the use of electronic communications in international contracting. So, creating certainty for the contractual parties that the contracts and other communications which are being exchanged electronically, they are as valid, also enforceable as their traditional paper-based equivalents. So the scope of the uh, Electronic Communication Convention is broader than that of the UNCI TRAL treaties uh, because the United Nations conventions on the use of electronic communication conventions in international trade. So it is not limited to the sales contract, although it is still aimed at only your commercial contract. So we have contractual parties, they may of course opt out of its provisions, like the limitation conventions, the rule of uniform interpretation for the electronics communication conventions, they mirror those found in the CISG, making more general, rather I would say, categories of research resources relevant. Then we have national laws also, because parties may also choose uh, national laws and this selection to apply to their international commercial contracts. So the party with greater bargaining power, what they may do, they may insist on its national laws, or parties may instead choose the law of a third state, usually one concerned to have a well-developed law with regard to your all kinds of commercial transactions. English law is frequently used in international transactions, in particular with reference to reinsurance. Or chartered parties, or sea trade, trade involving sea route, among other areas. So here, parties may select Swiss law. Why Swiss law? Because of the perception that the Switzerland's political neutrality makes this a neutral law. None other than that, political neutrality uh, may not always be the best guide as to the suitability of chosen law, that too for a specific transactions. So ICC International Court of Arbitration in 2013 statistical report mirrors 2010 survey. They all indicated frequent choice of German and French law. When considering these types of surveys, uh, one thing strikes to my mind that it is quite important to recall that generally the choice of law of any CISG state will also include the CISG unless the convention's applications is clearly excluded by the parties, otherwise not. And we have soft law, and when we are talking of the soft law and the trade uses, there are many. I would say, international text. There are many, I would say, having uh, international standards that may be chosen by the traders to govern their contracts. So these rules, when we are more concerned about, obviously, what is being done, they may be referred to variably as the rules of law, soft law, trade uses, and they are all connected by their use in the international contracting, and they're all connected in potential direct application by arbitral tribunals. Even otherwise, binding text such as the CISG may fall into this category when chosen by the parties to apply to their contracts without having any reference to a specific state law. So, like arbitral tribunals, the state courts may also recognize these rules, may also apply these rules, but depending on the relevance, depending upon the relevant domestic law, they may do so simply as a set of rules that are considered to be very much part of the contract and not overriding any of the things that we are more concerned about, that is mandatory law. So Hague principles, where followed, they may serve to further legitimize some of these sources. So Hague principle in Article 3 allow the law chosen by the contracting parties to be the rules of law that are very much generally accepted on an international level or your supranational level or even your regional level as the neutral set of rules, as a balanced set of rules, unless the law of the forum provides otherwise. So specifically naming the CISG or UNI DROID principles and the principles of European contract law in the accompanying contemporary. So few of the more prominent texts are generally discussed in this category of rule of law, soft law, or trade uses, because when we are talking of UNIDROIT, UNIDROIT principles, that is your principles of international commercial contracts, the UNIDROIT principles of international commercial contracts were first finalized in 1994, again got revised in 2004, again got revised in 2010. So UNIDROIT continues to revise the principles as appropriate or currently considering revision meant to deal with specific aspects of long-term contracts. So while following CISG's approach in many cases, what we have seen that the principles, unit-right principles are a set of general rules of international commercials. Addition, in addition to that, they're all able to recover. They're all able to cover even areas that the drafters of the CISG were not able to agree upon. When I say not able to agree upon, such as validity, such as your agency, such as your assignments, among others. Also, unlike your CISG and UNIDROIT, principles are not a binding test, but will generally be applied where chosen by the parties through application by the arbitral tribunal with some kind of authority to do so. Significantly, what we have seen that unit-right principles, they contain rules of interpretation from identical to almost identical to CISG, making case law. There will be some kind of your academic writings of great use in interpreting the principles. In addition to the unidroid principles, have a built-in commentary, which are also very much there, gives detailed guidelines. So the advantage of your, you can say, uh, principles of your international commercial contracts, PICC, is that they don't favor our particular domestic system of contracts law or even the legal system, but rather they provide a neutral set of rules. And when I say neutral set of rules that combine the best practices from the legal systems around the world. So, in this case, we have to see that in 2015, the Hague Principle on Choice of Law in International Commercial Contracts, they were all adopted by the Hague Conference on Private International Law, might trigger welcome change. And when I say welcome change, continuously improved since their first inception way back in 1983. Then the PICC principles of international commercial contracts have been described as a restatement of your international contract law, and that is how the PICC, that is your principles of international commercial contracts, could function as a new lex uh, mercatoria. Lex mercatoria has been described as a synthesis of generally held and generally accepted commercial principle that may be uh, expected to be applied to contracts among the major trade unions. So there is a controversy surrounding the lex mercatoria, in particular the specific to its contents. But when we look at the arbitral tribunals, they can none other than when authorized apply these principles. Certainly, the contents of the lex mercatoria may be informed by, in fact, the contents of international instruments such as CISG unidroit principles. For an example of a contract clausing or contract clause containing thereof, uh, and a contract clause containing choice of such broad principle, consider the United Nations General Conditions of Contract, which state with regard to dispute settlement that whenever you go for a decision of the arbitral tribunal shall be based on the general principles of international commercial law. So, in this case, uh, what is important that Incoterms is important because in specific area, the delivery of the goods, the International Chamber of Commerce (ICC) has developed a set of rules governing terms, trade terms that describe the obligations and the obligations of the buyers, the obligations of the seller, and supplement any other rules governing the contract. So in this case, the terms are in the combination of three letters. For example, one is FOB, standing for free on board, and Incoterms rules over the two bears, those who bears the risk, those who bears the obligations when the seller has contracted to deliver goods in this way, namely on board, obviously the vessel nominated by the buyer at the named port of shipment, and the procedure of goods already uh, so delivered. So these Incoterms come with the instruction as to how parties can incorporate them in their contract. So there may have been various versions of the rules, and the most recent the Incoterms 2010 and 2020, and they were first published in 1936. Incoterms 2010 defines 11 rules. They are upgraded as per the trade practices. Now coming to the model contracts and the clauses, the international contracts refer to a legally binding agreement between the parties. And this agreement, I must say, it is all based on different countries, and that too, in which they are all obligated to do or not to do certain things. So international contracts may be either written in a formal way. Most business, mo- many, why many, most of the businesses, they create contracts in writing to make the terms of agreement clear. Because often speaking, legal counsel when drafting important contracts, and contracts can overall aspects of the can cover contracts can cover all aspects of international trade, although most commonly used are your international sale contract, international distribution contract, international agency contract, international sale representative contract, international supply contract, international manufacturing contract, international service contract. There can be strategic alliance contract. There can be a joint contract. There can be franchise contract. Because model contracts, which I told you right now, they are all particularly useful for the purpose of preparing international business transactions. But they are often expensive. So the International Trade Center, what do they do? They offers the free online its model contracts for small farms, or the legal guidance which people they seek for doing international business. And when finally you have ICC office for purchase, an array of model contracts are there for international transactions, including an influential model for the sales contract. Because the contract are the products of some of the finest legal minds, and that too in the field of international commercial law. They're all constructed to protect the interest of all the parties, and in fact, combining a single framework of the rules with some kind of flexibility, with some kind of flexible provision, allowing the parties to uh, insert their full requirements, their own requirements. And in this connection, it would be appropriate to mention that there should be assessment of sale of goods by transfer of property, and that too transfer of property with certainty, transfer of property with flexibility. So when you are using the word transfer of property, obviously it takes place when the contract is concluded, even though the delivery, even though the payment of price happens subsequently. So this principle was adopted by the French law by Code Civil of 1804. So the same appears in the English law, and it all set out in a Sale of Goods Act, SOGA 1983. I beg your pardon, it is 1893. So the other system of transfer of property, that is all stipulated by the delivery, which was seen in German law, which was seen in Australian law. So the former talks of abstract delivery, and the latter, that is the Australian, with some kind of casual delivery. So the delivery property, that is the ownership, belongs to the realm of the general formulas, where the solution of the various parties, um, what they do, they always look for the solution, and that too, the former one of abstract delivery and the latter one is some kind of casual delivery. And when you go for transfer of property, that is ownership belongs to the realm of the general formulas, and while the solution of the previous practical problems, they belong to the realm of your operational rules. So these are all observed that even the legal system with contrasting general formula can share identical operational rules. So when uh, question emerges from the perspective of the ownership, obviously the judge must refer to the domestic law applicable according to the usual rules of contract, and the absence of the precise rule in the CISG is not loophole. It was a deliberate price by the drafters to leave it the judge to decide it. It was highly sensitive aspect in the sale of goods, and they facilitated the adoption of CISG, and that too by divergent legal systems. They adopt one solution or other for the domestic use. So certain degree of certainty is attributed to the sale of law, and these are all for providing guarantee the maximum predictability of the solutions act by the judge and the arbitrator. This implies that legal rules must be the precise as possible and must avoid loopholes, generic directives for the parties, or the fulfilling interpretation gaps for the decision of cases. On the other hand, they any say law that contains general clauses such as good faith principle binding the contracting parties to behavior whose legitimacy is very much decided after the event by the judge or the arbitrator. So, in all occasions, uh, the good faith has to be there, while the latter, good faith with the latter, and the good faith with reasonableness permeates the entire spectrum of contract relationship. So there is always a tension between certainty and the fairness of solved fairness that is solved by the CISG principle. So now it is high time to talk about CISG influence on the individual national system, because it was all noted by the scholar that CISG is having impact regarding both sales and goods. So obligation law and your contractual law generally on the numerous legal systems. So its influence on the individual legal system may be felt by the courts, and fed by the courts by doctrine, and that too the legal practice by the legal lawmakers, because Dutch judges use the CISG principle in interpreting the nation's way law, the interpreting the national law regarding the formation of contract, breach of contract, non-conformity of goods sold. Because if you look at the Scandinavian countries, except the Dutch, they have all revised their National Sale of Goods Act, and that is in line with the most of the principles that CISG, Finland 88, Norway 89, and Sweden 99, and your Iceland in 2000. CIC definitely influenced Europe by the Law Arbitrator Act 2002, which is identical transposed bindings, nature, uses, and practices, because the objective uh, interpretation of the declaration of intent, the freedom of the form, the mitigation of harm, and the prohibition of the abuse of rights. So you have Telugu Island, which has adopted the rules of CISG as domestic law for the sale of goods and for the general contract law. So the largest economy, where do you find? That is China. The CISG has essentially become part of the domestic law. So the law, contract law, 1991, was simply only supported by the CISG rules. And that is why the drafter that we are more concerned about, drafter of new Chinese civil code, they were able to find in the CISG a very important resource of rules, uh, both for the sale of goods and the contract law, that in general. So, in some legal systems, reforms in the national laws have begun, and they have been suggested that the New Zealand Sale of Goods Act 1908, that is an example of this reform. The largest economy in Africa, Nigeria, though not ratified the CISG, um, Nigeria Law Reform Commission began to consider a reform of the Sale of Goods Act 1893. It reproduces the old English law on sale of goods, and now there is a call for the reform to take the CISG as model law. So Japan didn't ratify the CISG for a long time, but the scholars, they noted the CISG rules, which are arguably better than the Japanese sales law, and the ongoing reform of the Japanese law of obligation would raise the law of reception of CISG principles and the rules in the Japanese legal systems. Similarly, the Turkey Code of Obligations deeply reformed the contract law, which was based on the Swiss model adopted in 1920. So 17 Central American countries, 17 Central African countries, who are currently the members of the Organization for the Harmonization of the Business Law, and that too in Africa, intended to remedy the legal uncertainty and the judicial uncertainty that exists among the signatory states. So in 1997, they all adopted a uniform law governing your commercial law, which was again subsequently modified, and the modernized came way back in 2010. And this regulates all the sale of goods between companies, and also exclude the sale of consumers. So with the French culture adopted by CSG, the principles of domestic law, domestic sale of goods, or including several rules, we are today also deriving from the English common law. Now coming to the regional effort that is being put, obviously the regional effort that we are more concerned about Now, coming to the regional efforts, the preamble to CISG states that the adaptation of the uniform rules. Why it is required? Because to govern, which govern contracts for the international sale of goods, they take into account the different social systems, different economic systems, different legal systems, because that would contribute to the removal of legal barriers in the international trade, and that to promote the development of international trade. So we have European Commission. European Commission also proposed a uniform, uniform law, new uniform law on the sale of goods, intending to solve the problems which are arising from this diversity of national contract laws. So the common European sales law, in fact, governs sales to both consumers and the businesses. So the common European sales law, CESL, would then offer a new choice between the legal system that the parties can make freely and any national law, either the European Union members or of other states. So we have got Association of Southeast Asian Nations approved the trade in goods agreement. So these treaties expand the free trade area beyond the borders of the community of Association of Southeast Asian Nations, and envisage the gradual, it cannot happen overnight, so gradual implementation of the free circulation of goods between ratifying states, elimination of your customers and protectionist barriers. But however, these treaties don't contain rule to be applied to the international trade contract, but obviously they are limited to your encouraging strong regional standardizations. So the Hague have recently established your regional centers that offer a significant opportunity to promote various private international law instruments, including those you're relating to international contract law in the light of the importance of the issue, efforts being made by the Secretariat, the UNCITR AL Secretariat, uh, where you have the Secretariat to welcome these how to explore other means of promotion, other means of promoting, other means of maintaining uniformity in the interpretation of CISG. The Secretariat recently proposed the establishment of a system of national centers. It is a national system of expertise in the field of uh, commercial law that go beyond the current national correspondent system of case law on the um, in citral. So adding to the secretariat, the system would collect, analyze and monitor the national law related to the text, report the findings, address the need, necessity of the judiciary to better understand the internationally prevailing applications and the corresponding uh, interpretation of standard, and finally they try to achieve the effective cross-border cooperations, because that is what is very much required, in the sense that um, uh, the analysis of the battle of the forms make it clear that the knockout rule is always supported by the scholars and the cases, because of the advantages such as conformity within the intents of the parties to the business, and how best you can have balanced and fair approach, apart from supportive approach to the contract, including the validity issue, and finally providing application to the convention by referring to its provision of case of knockout terms. So if we finally come to the COVID-19, the pandemic and its impact on the performance of international sale of goods contract, a force majeure clause in international sale of goods contract relieves a party from performing its contractual obligations when certain circumstances you come across and those circumstances beyond its control areas, making performance inadvisable or commercially impracticable, or illegal, or even make it impossible to so far as happening is very much concerned. So CISG Article 79 provides that a party is not at all liable for a failure to perform any of its obligations, because if he proves that the failure was due to an impediment beyond his control, and he could not reasonably be expected to have taken impediments into account at the time of conclusion of the contract, or to have avoided or to overcome it or its consequences. So the treatment that we are more concerned about, treatment of impediments under the CISG, is different from the treatment under common law. So generally, four conditions must be satisfied to assert the force of major protection of the CISG. That is, the impediments must be beyond the party's control. Secondly, the impediment is unforeseeably unforeseeable, maybe at the time the contract was signed. The impediment and the corresponding consequences could not be reasonably avoided or overcome. And apart from that, the fourth one is that the non-performer of the party, that is the result of the impediment. Because under Article 2 of the Uniform Commercial Code of US, what it states that the seller may be excused from the delay. The seller may be excused for non-delivery of goods if performance has been made impracticable by others. So the occurrence of an event, the non-occurrence of which was a basic assumption on which contract was made, or even good faith compliance with foreign regulation, good faith compliance with the domestic government regulations. So common law doctrine of frustration and your impossibility may be invoked, but to have a higher threshold. So that is why when we go for predating the pandemic 19 and COVID-19 pandemic, well-known example of such type of contractual arrangements that are found in the model clauses issued by the International Chamber of Commerce, namely ICC 2003 major, that means that is a force of majeure clause, and the ICC hardship clause. This was changed with the ICC's 2020, because hardship clause was which suggests three different legal consequences in the event of your uh, failed renegotiations, any of which parties can choose when concluding the contract, either the termination of the contract by one of the parties, or termination of the contract by the judge or the arbitrator, or finally, there can be adjustment, there can be termination of the contract by the judge or the arbitrator, because we have to combat uncertainties for future crises, just like your COVID-19 pandemic. It is therefore advisable to negotiate individual contractual clauses that pertaining to your force majeure and hardship, in order to determine the desired distribution of contractual risk in advance. So today, business to business international transactions going on, and it would appear that the market is operating effectively on that. We'll have differences in contract law, but they do not pose a serious obstacle to cross-border trade. With this, we come to an end of today's discussion. Thank you very much. Have a nice time. Good day.